Ms. Myers, we're ready for your argument.
May it please the court, opposing counsel. My name's Elizabeth Meyer. I represent the plaintiff applicant in this further review proceeding, Standard Water Control Systems. This case involves the competing rights of contractors that furnish improvements to homes and the homeowners that own those homes. Although this case began as a rather run-of-the-mill mechanics lien case, it is now on its third appeal before Iowa's appellate courts and is before this court on further review of the Court of Appeals decision on that third appeal. This further review proceeding does not concern the merits of the underlying dispute. Rather, it relates to Standard Water's efforts to enforce the judgment permitting foreclosure on its mechanics lien on the home at issue. I want to be clear that Standard Water is not before this court asking for a change in the law. It is my client's position that the Court of Appeals disregarded existing law. Standard Water is asking for enforcement of existing statutes and legal precedent interpreting the statutes. The procedural posture hopefully was well laid out in the briefs. I will not belabor those points, but just to be clear what was going on in the district court, this third appeal concerned a motion to reconsider a motion to vacate a writ of special execution on the second sheriff sale of the property at issue in this case. Essentially, the Joneses were arguing that their homestead exemption prohibited Standard Water from recovering the full amount of its mechanics lien through sale of the homestead. It's Standard Water's position that the Court of Appeals erred in two ways, and really only in one that the court needs to reach, is my position today. The Court of Appeals and the district court below incorrectly determined that a homestead may not be sold to satisfy the full amount of a mechanics lien. It's our position that is permitted according to Iowa Code Section 561.21 sub 3. And even if this court finds that homestead exemption is a defense and that 561.21 sub 3 does not permit sale of the homestead to satisfy the full amount, then the Joneses did not timely assert their homestead rights in this matter, and waiver would be another appropriate ground to reverse the Court of Appeals.
On the first issue, let's say it is the case, as we read the legislation after we're all done sorting through all this, that we conclude attorney's fees may not be recovered against the homestead. Would Standard Water still be able to assert a personal judgment against the Joneses for attorney's fees?
Standard Water has both a personal judgment against the Joneses in this matter pursuant to a breach of contract claim that it had in the district court. But today, we are concerned solely with the special execution on the decree permitting foreclosure on the mechanics lien. So the personal judgment is really a separate matter for purposes of this further review proceeding.
What sense are attorney's fees incurred for work done or material furnished exclusively for the improvement of the homestead?
So it is Standard Water's position that the Court of Appeals engaging in just a plain language analysis was actually incorrect. Two cases which are cited in our briefs, the Moffitt case and then a bankruptcy case in Ray Keene, have both examined the legislative history of this section in detail. 561.21 talks about classes of debts incurred. And even back in 1940, the Iowa Supreme Court had to look at the legislative history to figure out exactly what that meant. And it's Standard Water's position that the class of debt that encompasses those incurred for work done or material furnished would include both mechanics liens in their entirety and other claims that might be similar to a mechanics lien, where that mechanics lien wasn't perfected entirely. And that is really a proposition that is set forth in the Moffitt case, which is an Iowa Supreme Court case from 1940. In that case, the judgment was obtained by someone who had supplied materials. There was a promissory note. The judgment was inclusive of both principal, interest, and costs, and the court had to examine 561.213 to determine whether that successful plaintiff was entitled to sell the homestead to recover that judgment. It was actually the homeowner in that case that said, no, They can't sell the homestead to satisfy their judgment because they don't have a mechanics lien. The statute examined in Moffett is exactly the same as it is today. It has not changed since 1923. The court looked through the legislative history. Mechanics lien, the specific term, was present in that statute. And if you look at Keene...
I mean, could we distinguish that situation? First of all, I'm not sure that the issue of costs and interest was litigated there. But can we distinguish that situation that pretty much in any judgment in Iowa, you're going to get interest either pre-judgment or post-judgment, and you're going to get your court costs? Whereas here, attorney's fees is something new that the legislature added in 1983. But when they did so, they didn't say it can be recovered notwithstanding the homestead exemption. Didn't do anything to mention the homestead exemption. Isn't that a difference there?
Respectfully, I would say we should assume the legislature was well aware of 561.21 sub 3 and knew how this worked and had worked for many years prior to that the sale of the homestead would satisfy the entirety of a mechanics lien. Adding remedies for a contractor under the mechanics lien statute that might increase the amount of those judgments, the legislature should be presumed to have been aware of that when they changed the law and permitted attorney fee shifting in that instance. And going back to what I was discussing before, so in Moffett, the court looked at this, said, we believe that in 1923 the legislature intended to expand upon the rights under 561.21 sub 3, not to subtract from those rights. They weren't examining a mechanics lien. Specifically in that case, they were looking at something similar to it and saying, even though they didn't perfect a mechanics lien, they should still be able to sell this homestead. Similar to the Keene case, although it's persuasive authority, it's a bankruptcy case, that court specifically recognized that had the defendant in that case perfected a Chapter 572 mechanics lien, the homestead would be subject to the mechanics lien and could be sold to satisfy the debt under Chapter 561. Mechanics liens were one of those debts for which a homestead could be sold going all the way back to the Code of Iowa in 1851. This is a long-standing right of contractors. And it's important to Standard Water. The facts in this case, frankly, may not be appealing to this court. We're talking about a home of modest value and a judgment that the attorney fee award has been affirmed by the Court of Appeals on the second appeal that seems rather large in comparison. However, the decision of this court will have equal application to cases where the homestead has a very high value. Homesteads can be a half acre if they're urban. They can be up to 40 acres if we're looking at a rural property that's not based on a dollar figure amount in Iowa. And so we could be looking at a $500,000 home with a $20,000 judgment. It might not strike the court the same way, but applicability of Chapter 572 and its interplay with 561.213 will be the same.
But, I mean, we're looking at what the legislature intended, or we're looking at what they said, and sometimes what they intended is relevant. But I mean, it's possible the legislature wanted to draw a line between, say, commercial construction scenarios and said, okay, it's all right to get fees there because, you know, these are sort of big folks and the attorney's fees award is unlikely to dwarf the principal award, but might have been concerned about getting fees against an individual homeowner's homestead where it wouldn't be that unusual to have a situation like this if you took it through litigation, that the fee award was very large in comparison to the principal amount. Isn't that a logical division they could have made?
I think that's certainly one way you could view it. I would also note, however, that the legislature has also permitted homeowners in residential mechanics lien disputes to recover their fees if they're successful in defending against a mechanics lien claim. So on commercial matters, you don't have that for the building owner, but in a residential dispute like this one, the homeowner can also seek recovery of their attorney fees if they're successful in defending against that mechanics lien litigation.
But that makes sense, though, because the legislature is protecting the homestead. And by allowing attorney fees when they win and not allowing them when they lose is added protection against in keeping the homestead. I mean, so I don't see how it's inconsistent.
Well, and I understand that may be the court's view. In this case, it's our position that 561.21 has remained unchanged. Prior Iowa Supreme Court precedent establishes that a homestead can be sold to satisfy the full amount of this type of judgment, and we believe the Court of Appeals should be reversed. Alternatively, if the court finds that homestead was an appropriate defense in this type of case, it's Standard Water's position that the Joneses did not timely raise it. I expect Mr. Fatino will argue that they timely raised it by raising it prior to a sheriff's sale. However, some points that are important. A mechanics lien case is an in rem proceeding. The court exercises jurisdiction over a thing, that thing in this case being the home. Many mechanics lien cases are brought by a subcontractor, not a general contractor that has a direct contract. And so the court entering a judgment is only entering a judgment on the home. Two cases that we've cited, Frankson v. Miller and the Schiefert case, which is an Iowa Court of Appeals case from 2013, address these types of in rem proceedings. Frankson v. Miller actually involved a mechanics lien dispute as the first proceeding. So there was a mechanics lien dispute. The homeowner didn't raise homestead exemption as a defense. Judgment's entered. There's a sheriff's sale. A purchaser buys the home at that sheriff's sale, and that prior homeowner attempted to then assert his homestead exemption as a defense, seeking an injunction on that purchaser at the sheriff's sale taking possession of the property. And the court in Frankson found that the prior homeowner, that would be Miller, had waived the homestead exemption as his defense by not raising it in the underlying mechanics lien proceeding. So in this type of in rem proceeding concerning the property, it's Standard Water's position that the Joneses needed to raise that as soon as that defense was available on the merits in the underlying mechanics lien dispute. It was raised for the first time nearly 2 years after entry of judgment by the district court in Standard Water's favor. And I would note that the Joneses repeatedly argued in prior appeals that the attorney fee award was excessive because it would cause the Joneses to lose their home. They also raised that position in prior proceedings seeking to vacate the first sheriff's sale. Not once until this second sheriff's sale proceeding did they raise homestead exemption as a defense.
Isn't Frankson a little bit different? I mean, I agree. If you read Frankson as purely a waiver case, I think you're on pretty solid ground. If you read it as a res judicata case, it's a little different because in Frankson, there was actually a second separate lawsuit. There was an FED action. And as I read Justice McCormick's opinion, he sort of says, well, it was res judicata because it was already you didn't raise the homestead exemption in the first proceeding. Here, even though there have been 3 appeals, we're all still in one lawsuit, right?
Yes.
So isn't that a distinction there?
I suppose that's a distinction you could make. I think that's an unfairly narrow distinction. I think that Frankson and then the Schiefert Court of Appeals case indicate that in this type of matter, an in rem proceeding, and Schiefert was a partition matter, it is an affirmative defense. It's a defense that must be raised on the merits to prevent that lien from being a part of a foreclosure decree, essentially, is what Standard Water obtained in this case. It obtained a judgment that gave it the right to foreclose on its mechanics lien for the full contract price of the entirety of its judgment.
Wasn't the first sheriff's sale on all the business associated with that completely vacated?
That would be one reading. I'm not sure that broad reading is appropriate. That was not the main subject of our further review brief. However, the first appeal, the only portion of that judgment that was vacated was the dollar figure of the attorney fees. And so Standard Water's position, the remainder of that judgment should have remained intact. It was really just a dollar adjustment up or down on the amount of attorney fees.
But then there was a new sale ordered in the same purchaser, right?
That's correct.
So wouldn't that kind of defeat what you were saying, that they raised it for the first time? We can't really look back at that first proceeding if it was vacated.
And I think them raising it in that context was more a part of our judicial estoppel argument, which is not a primary argument here on further review. I think waiver, what we're arguing, and I think the proposition that Frankson and Schiefert stand for, is that it really was a defense that needed to be raised on the merits. Even raising it at that first effort to vacate a sheriff's sale wasn't sufficient. The Joneses, for this waiver argument, needed to have raised it in the underlying mechanics lien dispute. They did not. and their failure to raise it actually led the parties to waste a lot of time litigating the issue of attorney fees if they were never recoverable against the homestead in this Mechanics Lane case. I question whether the parties would have engaged in the same types of litigation. Respectfully, Standard Water would ask that this court reverse the Court of Appeals in Standard Water's favor. I'll see you back on rebuttal. Thank you.
Mr. Fatino?
Thank you. May it please the court, counsel. John Fatino for Mike and Corey Jones. Today's case is really about how easy it should be to waive one's homestead rights and whether an inadvertent waiver of homestead can occur under Iowa law. And because we are on further review, I'd like to maybe depart a little bit from my usual way of doing this because I want to focus on two things I've heard some questions about. One is that both the district court and the Court of Appeals agreed that the homestead was a defense to the Mechanics Lien claim. I think that's the first thing that I really want to point out to you because you didn't really hear much of that today. The second thing that I think is very important is what Standard Water is attempting to tell you the state of the case law does not exist. You keep hearing that we needed to raise this on the merits. And the case law is quite clear that the homestead right needs to be raised before the sheriff's sale occurs. And all of you, before coming up here, were either experienced trial lawyers or were district court judges. And imagine the scenario where what they're really saying is we needed to raise this as an affirmative defense. So let's stop the trial. Let me put on a bunch of evidence about an issue that isn't even germane at that point in time. That's why the Iowa procedure is quite clear that one needs to raise their homestead rights before the sheriff's sale. And it might put the apple before the cart in terms of the argument today, but that's why both Fraxon and that Sheffert case are distinguishable. Because in both of those cases, the case had already gone to sheriff's sale and they stood silent, and in Fraxon went to the FED case, and when they were getting evicted, complained that they had their homestead. And in Sheffert, and as I recall, they actually acquiesced in the sheriff's sale. So that's why I think those two cases are different. But let's go back to the very beginning and talk
for a minute about law of the case, okay, which is one of the other things. The first opinion, my colleague over here who's absent, who was then on the Court of Appeals, he said at the end of the opinion, we remand for additional fact-finding to determine award, meaning an award of attorney's fees, consistent with the facts presented in this case and the Schaefer factors. So he vacated the fees, and along with the rest of the panel, and sent it back for redetermination of the fees. Isn't that sort of law of the case that fees are awardable, though? I mean,
no, Your Honor.
Doesn't that control the right or wrong the rest of the proceeding?
No, because the issue was never actually raised and litigated with respect to the homestead issue in that first case, and one of the elements of law of the case is that it was actually raised and litigated. I mean, at best, you have this passing wisp of a reference to it, and that's why the district or the Court of Appeals found that the law of the case doctrine was not applicable there. And furthermore, Your Honor, the order was vacated at least from the Court of Appeals perspective, and the cases are cited for you both in our brief and in the Court of Appeals decision, that a vacated order is no longer a force in effect. And in any event, the district court went back and vacated its own order and ordered a second sheriff's sale. So to me, all of those issues about law of the case really go out with that second vacation, Your Honor.
But as I understand law of the case, an appellate decision, a decision doesn't necessarily matter everything that was litigated, but whatever is decided in the Court of Appeals controls the rest of the proceedings. So if they decided that some fees were awardable, isn't that kind of the end of that issue?
No, Your Honor, because under the law of the case doctrine, the issue actually has to be raised and passed on in a prior appeal. And in this record, you don't have any, and that's the Lee versus Polk County Clerk of Court case from 2016. You don't ever...
Another everlasting case, yes.
But you don't have that final adjudication that it makes the law of the case what the doctrine really is. So, and as the Court of Appeals found, there was no place in the prior appeal where the Joneses' homestead rights were actually raised and decided. So that's why the law of the case doctrine isn't applicable. But let's go back, if we could, Your Honors, to the point of Iowa Code Section 561.21 sub 3, that the plain language the legislature used was that the homestead can only be sold for those debts incurred for work done or material furnished exclusively for the improvement of the homestead. That plain language would exclude attorney fees from that analysis.
What is your position on the costs and the interest? Are they, can they be included or not?
Your Honor, as I recall, below we took the position that the costs and the interest were not recoverable. I think under that same language, that same analysis would follow, although I would acknowledge that the statutes with respect to interest and costs being recoverable on a judgment perhaps read differently, and the court might be able to reach a different conclusion with respect to interest and costs because there are other statutes that address that, but not the attorney fee provision, just because of the way the language reads. But most importantly, you know, in Iowa you have to find specific language abrogating homestead rights. And really what, you didn't hear much of it today because I realize we're here on a compressed schedule, but what they argued in both their brief and in the further review application is that Chapter 572 is the specific abrogation of the homestead rights. And as we cited for you in the brief, there is no special language in Chapter 572 allowing for the abrogation of homestead rights. All Chapter 572 says is that attorney fees are recoverable. And as this court has said, you know, homestead isn't only for the benefit of the family and their house. It is also for the benefit of our society and for the benefit of the state, that the state has an interest in making certain that people are secure in their houses and that they're not homeless and that sort of thing. That's the in re estate of Waterman. And that's why this court has said that it would construe the statute, the homestead statute, broadly and liberally in favor of homestead owners. Well, against that construct, when you go back to Chapter 572, there is no language in Chapter 572 that abrogates homestead rights. And indeed, one could conclude that the special provision given to homeowners exclusively for attorney fees in Chapter 572.32 sub 2 probably also does compete a compelling interest that shows the legislature sought a heightened protection for homestead.
But what's interesting about that is they specifically mention residential. I mean, here it would have been easy to say something like, except in the case of a homestead, attorney's fees are recoverable. Instead, they just said attorney's fees are recoverable.
Right. And I think, Your Honor, though, that goes back to the plain language of the legislation. You know, that when in Iowa, when the language is clear and unmistakable, you have to look at the language as presented, and that there is no special exception for homestead either way on the attorney fee provision. And I think that just shows you that under 561.21 sub 3, the homestead is sacrosanct under Iowa law. And again, let's move forward a little bit from where I'm at. But, you know, in the briefs, you heard about how horrible this would be for the construction industry. But when you think about it, there's only a very narrow class of cases to which this would apply. The holding in Standard Water would not apply in the commercial litigation context. It would not apply in the context of second homes. It wouldn't apply in the case of residential storage buildings where they're not the people's actual residence. So, you know, part of the public policy argument that's presented here in the briefs, but didn't really come up today, is this whole notion about how devastating this would be for the construction industry. And I'd submit to you that there is a very narrow class of cases to which this would apply. And both the district court and the Court of Appeals found that the plain language of Chapter 561 prohibited the homestead from being reached in this circumstance. All right, Standard Water also points to this language of Chapter 572, and there the statute says that in an action to enforce a mechanics lien, a prevailing party may be awarded attorney fees. That's all Chapter 572 says. And both the district court below and the Court of Appeals found that that language was not sufficient to overcome the language of Chapter 561 and the protection given to homestead. The other issue that we've addressed a little bit already is the public policy one that Standard Water spent a fair amount of time in their brief dealing with. And as I've already told you, I think it would only apply to a very limited number of cases. The important thing to contemplate is this, is that first of all, the plain language of the statute, it's our position, provides the correct result here. But also, it's up to the legislature to set that balance, and we believe that the legislature set that balance here by saying what it said in Chapter 572 and the appropriate language in 561. Because if the legislature, back in 83, when it made the change to allow for attorney fees, and then when it went back in that second time around to amend the attorney fee award, the legislature could very well have made corresponding changes to Chapter 561. And for whatever reason, it did not. And that's why, under Iowa law, when that language is plain and unmistakable, we don't need to engage in any sort of linguistic interpretation. We just apply the law as it's written. And I think one of the things that's very important in this case, when Standard Water talks about how devastating this would be to the construction industry, and I don't remember which of the justices raised this question, but in this case is a prime example. It does not strip them of their attorney fee award. They still have an attorney fee award because there was a counterclaim. We failed on it, and so under that anti-joinder rule of capital drywall, that when you assert a counterclaim, they can get an in personam judgment. So the Standard Water still has its in personam judgment, and there's nothing about the decision from the Court of Appeals or from the lower court that would divest them of that attorney fee award. It's just simply a matter of can you collect it against the homestead or not. The other thing that we haven't really talked a little bit about so far is really the waiver issue, and the district court found that there were three species of waiver as the district court saw it. That first of all, there was the doctrine of judicial estoppel. The second was the law of the case. We've talked a little bit about law of the case. And the third one was res judicata. The Court of Appeals rejected all three. We haven't talked about judicial estoppel, and basically what the doctrine of judicial estoppel, as the court knows, means that basically we've taken an inconsistent position, that we advocated for a position in a prior part of the proceeding that was inconsistent with a position taken later. And there's nothing that the Joneses have done in this case that is inconsistent with the fact that this house is their homestead. And in fact, as far back as 2016, when we moved to vacate the sheriff's cell, we raised the issue with the court that this is their house and that the issue of the attorney fee award and trying to bid for that.
So on your position on the waiver issue is that the homestead, let's say in a typical foreclosure, in any foreclosure action, the homeowner doesn't have to raise a homestead. They can wait, and then as long as they raise it before the sheriff's sale, it's timely.
Well, Your Honor, if I could, I want to distinguish that slightly, because in your typical foreclosure action, and if you're referring to a bank mortgagee...
Well, that's different because there probably wouldn't be an applicable exemption there. But let's say it's some kind of second mortgage, and they didn't recite they don't have a proper waiver and all that. They can just wait, and as long as they do it before the sheriff's sale, they're okay?
Yes, Your Honor. For the cases we've cited for the court and the way the statute works, the execution statute, you have to raise it before the sheriff's sale. Because otherwise, and this is not the case in this case, so I want to make this crystal clear, but hypothetically, you could have a situation where it was not their homestead at the time of trial, and it later became their homestead prior to execution. And again, the district court judges in Iowa are busy enough. So now I got to raise a hypothetical affirmative defense to something that's coming down the road. I just cannot imagine a district court judge in this state letting me put on evidence of my exemptions. I can't get into the fact that you can't levy on my shotgun and my musket and all these other, crazy things that they can't levy on in Iowa. It's just not the way it works. So for those reasons, Your Honor, that's why I think that's very important from the perspective of, yes, it has to be raised at the appropriate time, and the execution statute in Iowa is before sheriff's sale. So, all right, we've talked a little bit about judicial estoppel and how that we have not taken an inconsistent position in these proceedings. And again, I still think what Standard Water is trying to argue to make the rule is, which is not what the district court found and not the Court of Appeals, but that this somehow should have been raised as an affirmative defense, and we simply reject that. The district court never found that, and the Court of Appeals certainly never found that either. We've already talked a little bit about the law of the case and how we do not believe that the law of the case doctrine is applicable. The third is res judicata, and I think they've backed away from that. Standard Water has a little bit in their application for further review. But primarily there, the issue was not raised in a different proceeding, so the doctrine of res judicata doesn't apply. We already talked a little bit about how we believe both Fraxon and Sheffert are distinguishable because they're the party set silent through the sheriff's sale and raised it in a different proceeding. So unless the court has any other questions for me, I see my time's about ready to expire, so we would ask that you affirm the Court of Appeals on all the bases and remand the case for further proceedings, consistent with your opinion. Thank you.
Thank you, Mr. Fatino. Ms. Myers, do you have any rebuttal?
Yes, Your Honor. I'd like to touch briefly on this issue of, distinguishing between your normal case when it's appropriate to wait and raise homestead exemption and this case. In most cases, the sheriff's sale is solely a execution on a money judgment, your normal run-of-the-mill type judgment, not following this type of in rem proceeding that was about the real estate the whole time. Standard Water's petition in this case sought a decree permitting it to foreclose on its mechanics lien. It is more similar to a mortgage foreclosure where, if it wasn't raised, if they didn't have a proper waiver, there is a whole separate regime of law there, but it's not dissimilar. If an owner failed to raise that where there was no proper written waiver, I think that would be an instance where it was an affirmative defense that needed to be raised because it's an en rem proceeding concerning the real estate, not just your ordinary money judgment case where the prevailing party seeks to sell the home to satisfy its judgment. They're different. I also do want to briefly touch on the law of the case argument. Our briefing set forth, the language of the judgment entry in this case, which stated, Standard is entitled to an in rem judgment and a foreclosure of the mechanics lien in the full and total amount of the aforementioned money judgment, together with all accruing interest, costs, and fees. As Justice Mansfield pointed out, in the first appeal, the only portion of that judgment that was reversed was the amount of attorney fees. That was the only thing that was adjusted about the judgment when it was remanded to the district court. The Joneses did not raise any other defect in the judgment in the fact that the district court had ordered that their home could be sold to satisfy the entirety of the mechanics lien.
But you still have your judgment for attorney fees. The question is, can you foreclose on a homestead to collect it? I think they're two separate issues.
And I would like to touch on, prior Iowa case law. I'll cite from Winger Contracting Company v. Cargill. It's an Iowa case from 2019 from the Iowa Supreme Court, which recognized that the purpose of a mechanics lien is to protect persons who have supplied labor or material for the improvement of real property by giving the lien holder security independent of their contractual remedies against the owner of the land.
But that didn't involve a homestead.
I'm just noting the public policy behind mechanics liens.
What's the public policy behind homesteads, though?
To protect a homestead. However, the legislature has deemed under 561.21 that this type of debt is the type of debt that can be satisfied through sale of that homestead. I think we have to harmonize 572 and 561, and the appropriate way to do that is to find that a homestead can be sold to satisfy the entirety of a mechanics lien judgment, not just the principal balance that's owed. I don't believe I have anything further unless the court has further questions.
Just ask a question. Say the homestead is sold for the amount of the mechanics lien. Then is the rest of the property subject to the attorney fee lien still, or is the attorney fee lien cleaned off after the judicial sale? After the judicial sale, because it's no longer a homestead once it's sold, maybe.
I guess in this instance, the sale of the home, I believe, would satisfy the entirety of the judgment. So I'm not sure that I'm following your question.
Well, let's say we would hold, contrary to your position, that the lien only attaches to the extent of the work done. And then it's sold and it's bought by some third party who doesn't use it as a homestead. Does the lien stay with it, or does the judicial sale clean the lien off?
I hadn't considered that question, Your Honor. I'm not sure that I know how I would come down on that. It's possible that it would remove that lien through satisfaction through the judicial sale, but I don't think we've explored that, and I haven't had time to research it. I apologize.
Let me ask you a question. Mr. Fatino indicated that the reason why you could get an in personam judgment potentially for attorney's fees in this case, regardless of the outcome of this appeal, is because his clients asserted a counterclaim. Is that correct? If they had not asserted a counterclaim, would you be able to get an in personam judgment?
We would not. If the only right that Standard Water had here was under the mechanics lien statute and it had no contract with the Joneses, it would not have any other remedy. It would not have had a right to get an in personam judgment against the Joneses in this proceeding. All it would have had would have been the mechanics lien rights, and it would have been stuck with a worthless attorney fee judgment, absent that other contractual liability. Thank you very much for your time this afternoon. Standard Water respectfully requests that this court reverse the Court of Appeals and remand for further proceedings consistent with your order.
Thank you very much. The case of Standard Water Control Systems versus Jones is now considered submitted. You may adjourn court for the day.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.